Welcome everyone to this Privacy Rules, Privacy Espresso. Today I'm joined by our expert from India, that is Stephen Matthias from Kokar in India. Stephen is partner and he is also co-chair of the firm Technology Law Practice, that is the first of its kind in India. So I'm really pleased to be here speaking with him today. So without further delay, Stephen, I would like to turn it over to you. So thanks again for being with us, and please provide us with an update on how things are going there.
Thank you, Alessandro. Happy to be doing this small talk for privacy rules as usual. I'll start with the personal data protection bill that was released about 2 years ago. It was released as a consequence of a Supreme Court ruling, which held that the right to privacy is a fundamental right under the Constitution of India. The bill is largely moderned on the EU GDPR, but in some ways it's stricter than GDPR. For example, there is a mandatory requirement to obtain consent, and there's no route like legitimate interest under GDPR. There were significant provisions relating to data localization, and those were the most controversial and resulted in the bill not getting passed in Parliament. Instead, it was sent to a joint committee of Parliament to review. And unfortunately, with the pandemic early last year, the committee stopped meeting. And for probably more than a year, there were no meetings. And now the committee has completed its work and is preparing its report. In the meantime, the chairperson of the committee was made a minister in the government, and under the Indian rules, she had to resign from the committee. So there's a new chairman who's been appointed, and I expect the committee will probably submit its report in the next 2 to 3 months. The Speaker of the lower house made some remarks about not wanting to give an extension. So as of now, I do not expect India to have comprehensive privacy legislation in place before the end of this year. Probably end of this year is the earliest we could think of. So that's the personal data protection bill. In late February this year, the government passed new rules relating to intermediary liability. Now, what this is about is a provision in the Information Technology Act, which essentially gives a safe harbor to intermediaries, social media, web hosts, telecom companies, and so on, who may host or transmit data of others, but were not involved in that data in any way. And in order to avail of the safe harbor, one is to follow certain rules, and they changed those rules and essentially made them a lot more onerous. So there's a requirement of a grievance officer. There's a requirements of a grievance procedure. So if you have a problem, you can write in, complain. There has to be a grievance redressal procedure and so on. There were more onerous provisions placed on what they call significant social media intermediaries. And these are social media that have at least 5 million users in India. So there's a requirements of a compliance officer, and also states that the compliance officer could be criminally liable if the social media organization does not comply with the rules. Not every social media company has complied, and there's a fair amount of friction going on between the government and Twitter in particular. And I sense the main issue actually is around the compliance officer. And I'm not sure there's anyone in the world who really wants that job. And so there's some difficulty in finding someone like that. From a privacy perspective, there is one very interesting rule relating to messaging, and that is every messaging business must implement a way by which they can find out who is what's called the first originator of a message. So essentially, if A sends a message to B about C, which is say defamatory to C, and B decides to forward that message, it goes viral, and say 1 million people read that message, then the government wants to have the ability to go to the messaging company and say, we want to know who sent that message first. So WhatsApp has obviously not complied because they have end-to-end encryption, and they have stated that they will have to break the end-to-end encryption in order to comply. So that's a matter that's in court. In one sense, the government has a case because if there is content that violates law, then you want to know who put that content out there. On the other hand, what is essentially an innocent private message? And we must recognize between us, we say all kinds of things to each other, but we're not expecting those messages to be forwarded. We're not expecting them to go viral. But if they go viral, the intention is not to defame, the intention is not to publicize. So that's the other side of the coin, really. And there's obviously a huge privacy issue that's there in these intermediary regulations. The regulations also deal with publishers and require publishers to notify who they are. There's a grievance redressal uh, uh, procedure, and it follows three different layers. So if you have a problem with, let's say, a Netflix program, then you can write in and say, this is my complaint. And they would have an internal committee that would review that. And if you're not satisfied with that, then you would go to a industry body, which would be formed to look at these kind of complaints. And if you're still not happy with that, you can go to the government. The government also has the power to, on its own, take up, complaints. So the concern here is one of free speech. Will the government recognize different industry bodies? Would those industry bodies actually be fair? Because the reality is we have today in many countries a kind of a fight between the liberals and the conservatives, or whatever you might want to call them. And so one side may have their own industry, bodies. The other might do as well. And the reality is also that political parties are very, very, strong in social media in pushing their own agendas. So we are seeing a lot of content that's, plain inaccurate and very damaging. So conceptually, these are, good ideas, but how they implement it would really determine whether they are for the good or for the bad. So that's really about the intermediary regulations. There are a few other things that's related to privacy. Uh, Last year, India came out with the non-personal data report on wanting to regulate that and mandate some amount of sharing of that kind of data. There's been no progress so far. A couple of years ago, in the payment space, the government insisted that all payment data must be stored in India. And that includes the actual, the data relating to the payment by anyone who's within the payment ecosystem. And recently, the government issued an order against MasterCard, prohibiting MasterCard from taking on any new debit or credit cards because MasterCard had not complied. And obviously, it's tough for many of these, big international companies who may have one or two, data centers in a particular location, and then to create a new data center just for the India data can be quite tough. So the sense I'm really getting here is the government is kind of marching on in terms of regulating global players in the tech industry and particularly in social media. And this is leading to a fair amount of friction. It's leading to bad press for the Indian government. But there is also a sense, I think, globally that perhaps these companies have become too big and some form of regulation is required. Whether we can get to an optimal level remains to be seen. So that's my update for you on India. I hope you enjoyed it.
Thank you very much, Stephen. Indeed, it was extremely interesting and insightful. And I would like to thank our audience for following us. And I invite all of them to join the next Privacy Espresso with us. Thanks again and stay safe. Bye, everyone.
Thank you for having me. Bye.